Thank you, Mr President. I indicate that the Statute Amendment, Sex Industry Exit Strategies and Spent Convictions Bill 2024 is a conscience vote for the Liberal Party, as is standard practice for such matters in our party. I appreciate the passion that the honourable member has for this topic, as she has previously brought legislation as well. As the Parliament has only recently, in the last few months, dealt with a bill relating to legislating for prostitution, I do not propose to relitigate the issue more broadly. Should those listening or later reading the Hansard be interested in my philosophy around prostitution, I refer them to my contribution on the 1st of May 2024. I indicate from the outset that I will not be supporting this bill, as I believe it goes too far toward decriminalisation and deviates from what I would like to see in a legislative framework for prostitution. It is my concern that this bill seeks to weaken the existing legislative framework rather than strengthen it. In my belief, this legislation is a progressive step in the direction of decriminalisation, and as such, I cannot support it in principle. Throughout my contribution, I will refer to the impact upon women, as those who are prostituted are more often women. I acknowledge that this is not solely applicable to women. Given the existing legislation and the proposed bill uses the term prostitution, I will too, but I mean no disrespect in doing so. I'd like to make it clear that when we're referring to prostitution throughout my contribution, it's my starting presumption that we are referring to consensual prostitution in which all individuals are willing participants. Today, we are not legislating for rape, assault, abuse or sex trafficking. Whilst they are sometimes interrelated issues, they are separate offences and not what is being legislated for here today. Should that legislation not be sufficient, the state and federal parliament should address those issues, but the issues should not be conflated. Mr President, I appreciate that I may take a different and probably more conservative approach to this issue. One of the great privileges of living in Australia with a robust democracy is that we are able to have these debates and to share different views. One of the great things about being a member of the Liberal Party is that we are able to exercise our conscience in such votes. The day that people feel that they are not able to exercise their conscience is a day that we should all be concerned. It is with my conscience that I vote today. It continues to be my view that the best way to legislate for prostitution is through the full criminalisation of prostitution with what I would call safe harbour provisions. A legislative framework where those who are seeking police support, health services, HIV treatment and prevention, sexual health services or housing support could not be charged with prostitution-related offences when disclosing the offending for the purpose of seeking those supports, whilst also providing exit strategies. This is a model that I have previously spoken about and refer to my contribution from the 1st of May. As acknowledged at that time, the support for such a model would likely not exist in this chamber. I raise this model today to clearly articulate where I sit on the political pendulum in looking at a legislative framework for prostitution. In determining whether to support the bill before us today, I have sought to determine whether I believe the status quo or the proposed bill better align with my values on this issue. It is my view that the status quo better achieves this. The bill before us today provides for spent convictions that are, in my opinion, too generous, reduces the existing criminalisation of the sale of prostitution by providing immunity provisions, going further towards a decriminalisation model rather than a criminalisation model, does not target the purchaser and addresses exit strategies. As a general principle, I support the provision of exit strategies and would have been willing to consider spent convictions had they been stricter in their application. In speaking with current and former prostitutes, I appreciate that there are many barriers to leaving prostitution, and this is particularly the case if someone has a conviction. I think it is important to highlight that, as an example, between the 1st of January to 30th of June 2024, no person received a conviction in court for the Section 25 and Section 28 offences under the Summary Offences Act. I also think it is important to note, on information I had been able to gather via FOIs, that there were no arrests and no fines imposed for keeping or managing a brothel during the date range of the 25th of September 2022 to the 26th of September 2023. There were, however, 5 reports for the offence of keep brothel within this date range. There were no fines imposed for soliciting for the purpose of prostitution during the date range of the 25th of September 2022 to the 26th of September 2023. no arrest or fine issued for living off the earnings of prostitution of another person, including escort services, during the date range of 25th of September 2022 to 26th September 2023, and no arrests or fines issued for procurement for prostitution during the date range of the 25th of September 2022 to 26th of September 2023. Despite this, we must still be satisfied with the legislation this Parliament passes for when it is utilised by law enforcement. I have a series of concerns with the provisions set out in this bill for spent convictions. Some of these include the ability for those who have been keeping and managing a brothel to apply for spent convictions. It is my view that these persons have been exploiting the vulnerability of women, and as such, any spent conviction being granted is fundamentally a very different proposal to providing spent convictions to prostitutes who are often vulnerable and exploited. I do not support an extension of spent convictions to those keeping and managing brothels. I believe the requirement for the prostitute to not have been providing sex in exchange for payment for at least 3 months to be insufficient. I do not believe that 3 months is sufficient time to be able to establish sustained change of pattern of behaviour. I believe that ultimately this presents the risk that someone may be able to have their convictions spent and then later go back into prostitution. The bill also establishes that the exclusions set out in the Spent Convictions Act do not apply to a prescribed prostitution offence which is otherwise spent under Section 8D. Practically, what this means is that people who are applying for Working with Children check or police check do not have to disclose their conviction, and as such, prior offence is disregarded. It means that someone who is looking to care for children, vulnerable people, to work for SAPOL, for example, will not have to disclose their conviction. I do not support the removal of these exclusions. Whether someone has had a conviction and shown a pattern of behaviour where they have been breaking the law, especially if they were managing a brothel, is directly relevant to whether they would have been deemed a fit and proper person. I'm not saying this to disparage people or to suggest that their past conduct should forever jeopardise their future, and it is not to say that someone who had a prior conviction would not get a future role, but it is relevant to whether or not a person is suitable in some industries, particularly when working with vulnerable people or in a position of power. Whilst I do not support the provision of spent convictions as set out, it is important for all legislation in this place to be workable. I'll highlight some of these practical issues despite my not supporting it. I question how someone will prove that they have left the industry and to prove they do not intend on going back. This is something that has been raised as a concern with me by sex workers. It is my understanding that this is predominantly a cash-based industry, and as such, I imagine this may prove difficult. There is a requirement for an application to the Minister be made to access spent convictions. I note my thoughts on the application to the Minister set out here also apply to the proposed amendments to the Summary Offences Act. I acknowledge it is highly likely that there would be an inherent mistrust in coming forward and disclosing offending in an application to the Minister. It should also be acknowledged that there may be literacy barriers or English second language barriers that may make accessing such provisions challenging. There is no requirement for the applicant to have meaningfully engaged with the exit strategies prior to accessing spent convictions or the immunity provisions, merely that an application needs to be made. As a result, I fear that such application effectively becomes a tick box exercise. As a Liberal member, I believe in minimal government intervention. As such, I query why those who may be able to seek employment or housing independently are not looked to the government, are not able to access the legislative framework unless they have gone to the government. Whilst I do not support the framework, I merely look to query why government intervention must be thrust upon people in order to benefit from the provisions this bill seeks to achieve. The bill seeks to amend sections 25 and 28 of the Summary Offences Act, which deals with soliciting and keeping and managing brothels, to provide what has been described as immunity. This is one of my key fundamental issues with the proposed bill. The starting position is that someone has committed an offence under the Summary Offences Act. This bill does not remove soliciting or keeping and managing brothels as offences, and by creating immunity provisions through this legislation, we are acknowledging that these offences still exist. Despite this, a person would be given a free pass from future charges being laid for prior offending, if you will, should they meet the criteria set out in the bill. In my opinion, you either commit an offence or you don't. If you are soliciting or keeping and managing a brothel, such activities are either offences or they are not offences. Immunity provisions operate, in my view, in a manner which can lead to clunky and perhaps undesired consequences. Put simply, if we are going to view soliciting and managing and keeping a brothel as a criminal offence, then it should be treated as such. Similarly, if components are to be decriminalised, as for example in the Nordic model proposed earlier this year, then it should be treated as such without exemption. In my view, therefore, laws around prostitution are either all in or all out, and immunity provisions seek to muddy the water in this respect. Perhaps if I could use the example of selling drugs, Mr. President, if a drug dealer ceases to sell drugs, it does not mean that they have not previously committed an offence and should not be held responsible. I disagree with the premise that because someone has decided to no longer commit an offence and has decided to seek help through the minister, that their prior offending is absolved. Whatever the reason, a decision was ultimately made to enter prostitution, even if through desperation, even if vulnerability is involved. And to be clear, I'm not saying that someone does not deserve a second chance or that prior judgment should determine what opportunities one has in their life, but personal responsibility should not be negated, and, in my opinion, such personal responsibility serves as an important deterrent from entering prostitution in the first place. Further, I disagree with such immunity as it weakens the existing legislative framework. As mentioned, I support the full criminalisation of prostitution. The proposal of providing immunity moves too close to a decriminalisation model for my comfort by working to erode the existing criminality. This is not something that I support. Whilst I disagree with immunity being provided for soliciting, I take particular concern with the provision of immunity to those for keeping and managing a brothel. I appreciate that the member has made clear in her second reading contribution that the bill does not give the benefits of spent convictions and immunity to those who are running brothels in the conventional sense or those large-scale operations, and that she has deliberately confined it to a narrow group of people. However, I'm not comfortable allowing immunity for those who have operated a brothel, no matter how small it may be. If someone is managing a brothel, in my belief, they are preying on the vulnerability of other women and should not have the privilege of immunity purely because their operation was smaller. In my opinion, managing a brothel is unethical, and postulating about what size a brothel is irrelevant. I further note concerns around the wording provided for in the clause, not more than two persons provide sex in exchange for payment in the brothel at any one time. I query if the unintended consequence is that it establishes a loophole for organised crime and for more than two people to ultimately be operating out of a brothel. It should be noted that unlike the definition of exited the sex industry provided for in this bill for the Spent Convictions Act, the definition set out in the bill for exited the sex industry for the offences under the Summary Offences Act does not provide any time requisite for the individual to have been out of the industry to access such immunity. This is not something I support. I further note this leaves open the possibility for loopholes to be exploited. I have already highlighted my concerns regarding the workability of the application to the Minister to access exit strategies and do not propose to relitigate them. I do, though, highlight that when someone puts in an application to the Minister, they do not have to have exited the industry already. This further shines a light on the lack of waiting period before someone can access said immunity and opens the possibility for someone to use this as a loophole. To be clear, I support exit strategies, but a series of questions have been put to me and I seek to pass them on. Are supports that are to be offered intended to be new supports and programs, or is the intention for the Minister to refer to existing services? Is it proposed that there would be additional budget for these services? Is the Honourable Member's intention that the provision of education and training services means to pay for degrees or qualifications for applicants, or is it to direct them to existing opportunities? What is the burden on the Minister? Is it merely providing a phone number that will satisfy this obligation? Is the applicant to be given long-term or short-term housing, noting we are in a housing crisis? Is there an obligation for those applying to the Minister to be given higher priority for housing than others on the list? Does assistance in accessing legal practitioners mean referring to legal aid, or is it assisting in costs? This bill seeks to delete phrases like engage in procurement for prostitution and substitute it with procure a person to provide sex to another person in exchange for payment, or prostitution of another person and replace it with sex provided by another person in exchange for payment, or remove prostitution and substitute it with sex provided in exchange for payment. In my opinion, it appears contradictory for such changes, which would ordinarily be used to normalise an offence or even decriminalise it, to be inserted when the bill retains criminal offences for prostitution with spent convictions and immunities therein. If we are retaining prostitution as an offence, I do not support changing language around this. Mr. President, I know these are not my only concerns with the bill, but articulate some of my key reasons why I will not be supporting it today. Fundamentally, I take a more conservative approach to this issue. Given there are no recent convictions recorded, I see no urgency in rushing through legislation that, whilst has good intentions, the unintended consequences for vulnerable women have not been addressed and has many components that do not sit with my conscience. It is my firm view that the existing legislative framework or status quo better provides for the criminalisation of prostitution, and that the proposed bill acts to further decriminalise certain behaviour should the individual meet the established criteria. I think the criminalisation of prostitution acts as an important deterrent from entering into an industry I do not believe should be a viable career prospect, particularly for young women. It is my belief that the best way we can support women is to stop them from entering the industry and to criminalise the sale of prostitution in the first place. In summary, I oppose the provision of immunity and believe the spent convictions provided for in this bill are too lenient, and I'm particularly concerned around the extension of immunity for those managing and keeping brothels. Unlike the honourable member's previous bill based on the Nordic model, this bill does not address the purchase of sex or hold those who are exploiting women to account by criminalising the purchase. As such, given the proposed bill is walking away some of the existing criminal elements, but not addressing the gap in reducing demand, I cannot support it. For the avoidance of doubt, I do support providing exit strategies for those who are in need should they want to access them. I indicate that I will be supporting Amendment Number 1, Centofanti 1, and that I will be opposing amendments in the name of the Honourable Tammy Franks and the Honourable Emily Burke. With this, Mr. President, I conclude my remarks.